Hello, everyone. It's Richard Fink, the workers' compensation lawyer, uh, doing the Richard and Paul Injured Worker podcast. Paul?
Hello, everyone. My name is Paul Taylor. I'm a licensed paralegal by the Law Society of Ontario with a specialization in human rights law and workers' compensation law. If you want to reach out to either one of us, Richard or myself, or be part of our podcast, like our special guest today, Glen Shore from California, you can connect through us through the links below. This week's topic, we're talking about the comparison between Ontario's workers' compensation system and laws and California's and the US in general, but specifically with California because that's where Glenn is from. Glenn is you know what, I'll let you talk about your background, Glenn, because I know it's probably massive and I could barely touch on it. All I know is he's a professor, research professor at Berkeley, if you can believe it. That's wow. University in California.
My background. Um, yes, currently I am it's called a lecturer, continuing lecturer at UC Berkeley, University of California Berkeley, in the School of Public Health. And the course that I teach there is a course on injury control and prevention. And I've been doing that course for probably 15 or 20 years. Um, but before that, and sort of during the initial part of that, I was an employee of the state of California in the state labor department, um, both in the Division of Workers' Compensation and later in the Division of Occupational Safety and Health, which is called Cal OSHA. And I worked for the state probably about 30 years. And during that time, had two times when I was not working for the Department of Industrial Relations, the state labor department. One where I was the principal consultant to the state Senate Labor Committee on Workers' Compensation, and this was during the early 2000s. And then during the Obama administration, from 2010 to 2012, I was a special assistant to the administrator of OSHA, to the assistant secretary for OSHA in Washington, D.C. So I was on leaves of absence from my state job during those two times. But my career started at the U.S. Department of Labor in 1978, where I was working on a study of occupational disease compensation. Um, between that, and I was working on that study, and we can talk about that if you want. But during that study, that was during the Jimmy Carter administration. And our office, after doing an interim report to the Congress on occupational disease, our office was eliminated when Ronald Reagan became president. So there was no interest from the Reagan administration on looking at that topic. Um, yeah, why don't you?
So looking at your background, I guess the one word would sum it up with wow. You have quite a bit of experience in this area that we talk about. So, in speaking about California's workers' compensation system and generally the US, I know, to my knowledge, and correct me if I'm wrong if you know, that pretty much all the states in the US operate like California, where you have a workers' compensation board, employers pay into it much the same comparable to Ontario. And I think there's two. I want to say Tennessee and Texas or Tennessee and New Jersey that they don't have any workers' compensation. The workers just sue the employer. Is that right?
Sort of. The one state that has that sort of system is Texas, where you have, instead of it being a mandatory system for all employers, and we can get into the discussion of what's an employer and what's not an employer. Um, in Texas, there's a system where they do have that sort of, the general system is sue your employer if you're injured on the job. But employers can opt into workers' comp if they so choose. Most employers probably don't. I don't know that much about Texas, but Texas is the only state currently that
Hmm.
has that sort of non-mandatory system. I think probably 10, 15 years ago, the state of Oklahoma um, started to move to the Texas system, and tried to eliminate that mandatory system, but I think it was overturned in a state constitutional battle. Um, I think the main difference between the US generally and Canada is that one, we don't have universal health care in pretty much anywhere in the
So when a
States.
worker gets hurt, it really impacts them when their claim is delayed or denied.
Correct.
Yeah.
And the other thing is that it's not a government run or government administered system in all but 4 states, I believe. So we have private insurance, private workers' comp insurance in probably 46, 40, 45 or 46 states where there might be a government fund. Like in California, we have something called the Compensation Insurance Fund, which
Hmm.
competes with the private um, insurance carriers, but an employer is not required to use the state as their employer. Whereas in Washington State, Ohio, Wyoming, and North Dakota, I think, are the 4 states where there is what's called an exclusive state fund. So that's where the government, where the state has they're the exclusive provider of workers' comp. And then I think, like Canada, I believe, um, an employer, a large enough employer, can petition to become self-insured, where
Hmm.
they carry their own risks, maybe hire a third-party administrator to administer the claims.
Yeah, in
Um,
Ontario, we call them Schedule 2 employers, I believe.
okay.
Is that right, Richard? I forget.
Well,
And
even Schedule twos, though, are part of the system.
yeah,
Mhm. I mean,
yeah,
these
yeah.
are,
The
yeah.
board administers the injury and stuff. I get confused by schedule because I don't generally deal with a lot of Schedule 2 because like 90% of them are government. That was the funny thing with Ontario's system
Mhm.
was there was, and I remember reading with Meredith and studying it a bit, was there was a lot of debate about including government into the premium system. And I think the
Mhm.
governments went, well, taxpayers shouldn't have to pay for employer accidents and stuff. And there was back and forth. So I guess they went with this system. And there's a lot of debate about it. Like the one thing I know, and correct me if I'm wrong, Richard, that if you're an employee of a Schedule 2 employer government and you're involved in an accident, you can sue a Schedule 1 employer employee if they caused the accident or whatever. Like
That's
sorry?
that's correct.
Yeah. So there's like it's not you've come like in Ontario or Canada, you've heard the term, Glenn, historic trade-off where
Mhm.
workers lost the right to sue their employer. In return they get a right to workers' compensation, and then employers are required to fund the system, and in return they get that, how would I say, is immunity. But there's, as I was saying, there is limitations, and this is where it almost seems like to say, I want to start saying, and I've been starting to say to workers that haven't been injured, if you ever get injured, I hate to say this, but the first call you want to make is to a lawyer, paralegal in Ontario, lawyer elsewhere, agent, whatever. You want to call them first because you want to preserve and protect your rights before you call the ambulance. And I'm laughing, going, wait a minute. Yeah, it's that important, sadly.
Mhm.
You know, um, I've noticed the one thing, and the history in Ontario is quite rich with workers' compensation, and seemingly in Canada started here. And in the study, I found several years after 1915 was the start in Ontario with the law. Then it went out west and east, and that,
Mhm.
1916, 17, 18, and that. Um, and what caused the shift was the observation of workers in that period of time in the late 1800s, where workers were literally getting killed, their families were left penniless, and this was the
Mhm.
move. What was fascinating was is the Meredith report. Have you ever glimpsed it, Glenn? Yeah, you're
Yes.
familiar with it. Of course you are.
Mhm. Mhm.
You're a researcher. And the way he came across it was the importance of separating the workers and employers, saying the employer's responsible for their workers when they get injured. And if this connection isn't maintained, then those workers then become a burden to society, a financial
Hmm.
burden.
Hmm.
And it was what I would call his revolutionary thought process in Meredith saying, it's not about, social programs and the caring of individuals and the have-nots or anything. It's actually protecting taxpayers. And I think this is often missed.
Hmm.
But what was fascinating was that I noticed in my observations and sadly living it, and I think Richard would probably chime in on this, was in Canada about the late 90s, we hit that shift that in America you hit in the 80s with Reagan, with that Reagan economics, which scholars, to my understanding, correct me if I'm wrong, they call it neoliberalism, where it's basically what I would call a survival of the fittest, cut social programs, cut, 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 cut. It's more important in the corporate world to cut costs than to expand and grow and create more business. And the famous one, I remember a labor studies professor saying to me, it's worth the hit as a corporate business, meaning corporations are leaning more to it's okay to be bad because it's worth the risk. And I've noticed that a lot in US and Canadian insurance industries where they've actually been, a lot of them have been hit hard with lawsuits and that because of their really bad conduct. And it's funny, there was a book, Insurance Bad Faith, we call it in Canada.
Hmm.
In the US, there was a really, really amazing book written about insurance, was Delay, Deny, Defend. And it was written by a law professor. I believe it was Pennsylvania Law School somewhere. I can't remember. I don't have it handy.
Hmm.
But these things I noticed too, like there was a massive change in the mentality of corporations and insurance companies and that. But then I also noticed in Canada, it was the same changes with workers' compensation. For example, and Richard will probably recall, is in 1990, there was a huge change with the workers' compensation law that went away from what I would call is the historic trade-off of where a worker has the right to workers' compensation
Hmm.
by implementing forced return, what I call forced return to work, meaning the employer, the board and the employer say, well, you can do that work. We don't care. No proof, no nothing. Then we'll suspend your benefits, right? It's
Hmm.
forced. Did
I
you
guess the
notice
question
that?
is, in California, do they pay unlimited wage loss if the circumstances dictate, or is it our cutoff?
That's a good question.
Well, it, I think getting back to the history a little bit, we started a little earlier. Um, the first, and I'll get back to the question of the limited or the unlimited benefits, but in California, the major shift came in 1911, where this was, and a lot of states it happened around the same time. There was a pretty well-known catastrophe in New York City, the Triangle Shirtwaist Factory fire in 1911, where 150 odd workers were killed in a workplace fire in a garment factory. And that event, I mean, there were other things leading up to that, but that event really sort of pushed the button for a lot of state legislators to say, no, this old system, like what you had, like where there was an employer liability and the employers could be sued, but they had certain defenses. Those defenses were really eliminated by the first by a voluntary law in 1911 and then by a mandatory law in 1913 in the US, in California. Most other states switched from an employer liability system to a workers' comp system or a workmen's comp at the time in the 1910s. There were a few states that took, I think Mississippi didn't have a system until the 1940s. But for the most part, all the states were shifting over during that earlier era, which in the US was called the Progressive Era. Um, so during the 1910s, California elected a progressive Republican, because at that point, the Republicans were more progressive than the Democrats. Um, and the governor, in his inauguration speech in beginning of 1911, said, "Yeah, we're going to move over to this system, workers' comp, because the employer liability system wasn't working very well, and people were unable to get benefits after a workplace injury for the most part. A couple of people would win cases, but for the most part, they wouldn't." Getting back to the question about the limitations on benefits, we pay, or the current system in most of the states in the U.S. is that the weekly benefits, if you're on temporary disability, if you're unable to work after a workplace, I don't like the word accident myself, but after a workplace incident, would be that you could get 2/3 of your gross wages. So would be up to a maximum, and the maximum amount would be often the point at which it would become unfair to workers, because say there was a, using today's terms, the person was making $100 a week. The workers' comp would say um, you can get 2/3 of your gross wages, so you would get $66 a week from workers' comp, but it would be untaxed. It wouldn't be, it's not taxable, which they thought was closer to, there's still, how do I say it? There's still almost a deductible, in the insurance business for getting injured. You're still, even though it's not your fault, you're still suffering the benefit, the harm from that injury, because you're only getting 2/3, and there's a maximum benefit you can get. And for a long time, California was at the lower end of the max, so there was people who were making over, much under the median wage, were cut off at a lower amount than the 2/3. I know that's a sort of long and maybe complicated uh, answer, but now in most states, the maximum is linked to what's called the state average weekly wage, so that all this, and the benefits can go up, are indexed so that they can go up with time. Um, I don't know, maybe is that too complex for the,
Well, I guess the question
yeah,
is, so let's say the worker's making 50,000 a year, which is roughly, say, 20,
$1,000 a
30
week.
bucks an hour,
Yeah.
loses an arm, has a mental breakdown. Will they pay him to re age 65 or till death, or
Mm.
and how much would he get out of the 50?
The current law, which was changed during probably in the last 10 or 15 years, 20 years, um, cuts people's temporary disability benefits at 2 years. Um, but that's for temporary disability. If you're permanently and totally disabled, which is a very rare case under the that's allowed under the workers' comp system, then you still can get these 2/3 of benefits for life. It's not cut off at age 65 like it is in Canada.
Yeah.
So he would get like 33,000 a year.
Well, 66,000. Oh, yeah, 33,000. Sorry. Yeah, two
And
thirds
at
of the
the
50.
two-year mark, do they just make a determination saying, well, you've only got one arm now, so rather than making 50, you could only make 30. We'll pay you 2/3 of the difference.
They would usually assign a permanent disability benefit that would measure how much you were. able to, what's your decrease in your ability to work. So you might get an award through a permanent disability benefit that can go on for life. But in most cases, I think those become settlements where the worker agrees to take a lump sum and then is restricted from getting any further benefits. So it sort of depends on the case. But
Do they base the future on sort of a chart? In other words, you lost an arm, so you're going to lose a third of your income?
yeah,
Or is it
there's
based on some kind of occupational assessment, look at your education, your work
mhm.
history, and come up with an assessment as to what someone like you with one arm would make? Which do they
Yes.
use?
Yeah, I think there's one of the elements of the state program, the California state program at least, is called the Permanent Disability Rating Schedule, which has been around since the beginning, since the 1913 mandatory law. And that does use several occupational factors to determine what your benefit should be. It's not, there are some states that will have a chart, sort of the body chart, where if you lose an arm, you get this much. If you lose a finger, you get this much. If it's your right hand, you get that. And if it's your left hand, you get less, if it's your dominant hand. But California has never used that sort of chart. It's always been a determination by a state employee as to what the permanent disability amount is.
And when the workers hit 65, so does that benefit stop?
Not that
Or
I
does
know
it
of.
go on
No,
to death?
the permanent disability. I I'm not a lawyer, and so I won't, try to guess or try to determine what it is today in California. But it does not stop by, the fact that you hit age 65 does not stop any benefits that you're getting. You continue on for life. Um, we get other, there are other social benefits in the state's social security system that people can apply for. Generally, it's a retirement system, but there's also a social security disability insurance system where if people are permanently unable to work, they can apply for what's called SSDI, Social Security Disability Insurance, um, at any age. So there are younger workers who get SSDI sometimes in addition to workers' comp. Often SSDI would come in because somebody was unable for some reason to get workers' comp. Either they were denied benefits and they didn't pursue their case or they lost their case. But the federal system of Social Security can come in and do its own determination of whether you're able to work and um, give you benefits under that system. It's not as generous as what the workers' compensation system is, which is not as generous as what you were making, prior to your injury.
So,
So in Ontario, we have about 6,000 cases per year that go to the final level of appeal. That uses usually a three-judge panel to determine various issues that workers bring forward in terms of negative benefit decisions. Is your system like that? That it's
Yeah,
very litigious?
yes, California especially is a very litigious system. The formal um, arrangement in California is if you're injured, there are 25 or so offices around the state of what's called the Workers' Comp Appeals Board, sort of the Workers' Comp Court. Um, and I think you have the same as we do, where workers' comp is the exclusive remedy for any workplace injury. And we have it. So you have a state court for workers' comp, And then there's a workers' comp appeals board, which the appeals from the state court from, I think we have something around 200 judges across the state in the general workers' comp court. And then the workers' comp appeals board, I believe, is a 7-member board appointed by, I think it's by the governor, and I think there's a few appointments from each of the legislative bodies, from the state assembly and from the state senate, um, to the workers' comp appeals board, and they handle the appeals. And it it used to be that most of the members of the workers' comp appeals board, the 7-member board, were attorneys until, well, I think it's still in the law that a non-attorney can become a member of the board, but it's limited to, I think, one or two of those 7 members can be non-attorneys. Um, but I can't remember the last. Well, I do remember the last person who was a non-attorney who was on the board. He then became an attorney while he was on the board, and that was back in the early 2000s, like 2002.
So last week I went to a get together on Zoom of the Ontario Federation of Labor. So
Hmm.
that the Federation of Labor is where all the unions, not all of
Hmm.
them, but most of them gather
Right.
to do legislative lobbying and um, meet to discuss general issues. And the Federation of Labor has a special subcommittee on workers' comp. The subcommittee meets, I don't know, every month or two. And the last one went on for about 4 hours, and it was 4 hours of grievance.
Hmm.
So it's not just litigation lawyers such as myself who do workers' comp, but the Ontario Federation of Labor, which does litigation on behalf of their members without
Hmm.
charge. They are also very upset with what's going on. Is that reflected in California as well, given you're a
Yeah.
little more liberal than we are?
Yeah. I mean, labor, the organized labor has probably somewhere around 10% of the workers in California as members. So most workers are not in a union. Um,
Yeah,
it's a number that's gone, down over the years, and probably the largest, well, the greater public employees tend to be more unionized than private employees. So
that's the same in Canada.
that's one difference. You would getting back to a different point, you had talked about the state workers or provincial workers or public employees as being sort of a separate class. We do have, for state employees here, there's another sort of level called legally uninsured. And that would be for state employees because the state acts as the self-insurer for those employees. So they don't have to, like the state Department of Labor doesn't have to buy a policy. There's they just it would be state funds that would go
Yeah,
into that
like
award.
your state employer would pay you directly for your time, your workers' comp, so to speak, and your healthcare and all that.
Yeah,
So
I mean
are unions like the auto workers not happy with what's going on in California?
I'd say nobody's really happy with what goes on in California. I think there is a, there is heavy litigation in California on anything that any injury, and we have, at least when I was working in the system, and I've been retired from the system for several years, so my numbers might be a little off, but there's about 1 million injuries a year in California, work-related injuries. I think we have a workforce of approaching 20 million people. And there's at least some injury to close to 1 million, somewhere between 700,000 and 1 million a year. And those if there's permanent disability, you really have to get a lawyer. Um, while the system is intended to be no fault and non-litigious, anyone who knows, anyone who has a case that involves money or involves a first denial by the insurance company or by the self-insured employer really has to get a lawyer to go into court, because it's a very specialized area, and those who try to do it themselves generally run into problems. Unions at one time did have a workers' comp committee within the state Federation of Labor. As far as I know, there's no workers' comp committee now of within the California Federation of Labor. There is an occupational safety and health group within the state federation, which often will handle legislation that's coming up around workers' comp. And the state federation is probably the most effective worker lobbyist on those pieces of legislation. But it's not, they're up against lots of other stakeholders. I don't know if I can show you this. It was, I don't know if you, probably not going to come through very
No.
well. No, it's a picture that I like to use in my class, especially where an injured worker is going to the elevator in the legislature, and he says, workers, and he's asking the elevator operator, where's workers' comp? And the elevator operator says, oh, workers' comp, turn right at doctor's compensation, left at lawyer's compensation, right at insurance compensation, go past lobbyist compensation and legislators' compensation, to the stairs at chiropractor's compensation, and it's after applicants' attorneys' compensation and vocational counselors' compensation. So there are so many different organizations that have a finger in the pie that California, and I don't know whether you use this term, but on the insured side of workers' comp in California, what we call the friction costs, sort of the difference between what an employer pays and what goes to the injured worker, is about half and half. It's sort of only about half of the money actually goes to the injured worker, and a lot of the other is just divided up into all of what the employer is paying in premium is going to other parties rather than the worker. And that's, you would expect some of that to be going to medical care, and I think that half includes medical care. So we're talking about non-benefits to workers that is eaten up by the litigiousness of the system. And California is way above most other states on that number, on the percentage of the premium that goes to litigation costs or what we call friction costs. So the amount that's going to the insurance companies, the amount that's going to attorneys on both sides, the amount that's going to any sort of vocational rehabilitation, which we don't have very much of anymore. I don't think anybody, back to your question, nobody's really happy with the workers' comp system. I think the employers are probably the happiest because their rates are continuing to go down year by year. And so they're fine and think that the system is operating okay. But I think it does turn into more and more cases where people have to be picked up by some other social insurance program if they're going to get
Defeats the
benefits.
purpose of compensation, doesn't it?
In a
In,
way.
Do
in
you have any
Ontario,
idea what the average rate is for an employer in terms of how much per
Yeah, well,
$100 payroll they pay?
it depends. It's there's something in California and in most of the states we call a rating bureau. In California, it's a workers' comp insurance rating bureau that collects all that information from the employers about their payroll and the amount of money that's going out for the workers' compensation costs for the workers. It tends to be fairly low. Again, this is a couple of years old, but it's under about 2% probably on average of payroll costs go to workers' comp. but depending on the occupation, it can be much higher or much lower. If it's a clerical job, it might be 50 cents per $100 of payroll, whereas many construction jobs are more like $20 per $100 of payroll, or
But you
maybe even
think the
larger.
average might be around $2 per hundred
Yeah, it's something I could look up, but I don't know the exact number now. But California
because
has always been near the most expensive for employers, but I know that they would not be interested in going to a system where we went back to being able to sue your employer um, for injuries on the job. So
I think
in
Ontario, Paul can correct me, I think we're down to about a buck 30 per hundred.
I think it's even lower now because they
Yeah.
said they reduced it again.
Yes, it
You,
might be
you,
around a buck 20. We're the lowest in Canada. And when my clients complain to me that they're not being treated fairly, I remind them that we're one of the lowest in the Western world. But perhaps there's states like Florida that are even lower.
Yeah, there might be.
the other factor that's
Yeah.
being missed though with the premium rate is the rebates that the board's been giving out over the past 2 or 3 years,
Hmm.
That's right.
which
That would
kind of
drive it down more.
conflates it.
more.
Yeah.
Yeah. I mean,
So,
I
yeah.
think it's about 10 billion now, so it really conflates the rate that the employer's paying.
Hmm. The
Is
getting
there
back to,
sort of a
yeah.
political thrust at all with workers' comp in terms of the population saying the system is bad, litigious, something has to be done? Is it at all a political issue?
Um, it currently, no. Back in 2004, when there was a recall of the governor in 2004, and one of the issues in the recall was the cost of workers' compensation. They were saying that the employer rates were getting too high, workers were getting too much. And that's when Arnold Schwarzenegger became governor in California. And the legislation that went through in 2004 dramatically reduced the employer cost because they cut the amount of benefits going into the permanent disability benefit by close to half. So the rates dropped as sort of going over a ledge
So this was a
for several
legislative
years.
change that just dropped the entitlements.
Well, it was a legislative change that the way it works in California is the legislature makes the law um, and the executive branch implements the law. Sort of like it would be anywhere. But the person that Schwarzenegger brought in to sort of specify what the law meant in terms of permanent disability use the vagueness of that law to really the cut and make it more difficult and applying. I think it was the AMA guides to what were how to determine permanent disability. So the rates went much lower for several years. They started to climb a little bit after that, but generally there's been no employer.
I think he's
um,
working in Ontario now.
yeah, well, there's really been no. It hasn't been a big issue in the legislature since then. There's been some bills um, in the later part of the early 2000s, but recently not so much. And there used to be a theory that uh, sort of every 10 years workers' comp would come up as an issue. Um, and it for a long time, before the 1990s, it took an act of the legislature to raise the benefit levels. We were not indexed to the state average weekly wage. And so California had a very low maximum benefit level um, until probably late 1990s. And it finally, during one administration, there was a trade-off, and workers' comp became indexed. The maximum benefit got indexed to the state average weekly wage. So now it's it's going up by basically inflation every year, the maximum rate, and that, I think, at least keeps things on a more even keel.
What
Though
is
the
the maximum rate approximately?
something like, I'd have to look that up too. Something around 13 or $1,400 a week.
Hmm.
So it's
That's
more.
way lower than ours, which is about 108.
Mm. Glenn, the one quick,
Oh, final word, Paul. We're at the
yeah,
end.
final
So,
question.
Oh, oh wow.
I just wanted to talk to you about your area of expertise, which is research in that. And that the one thing I've noticed in studying workers' comp in Canada and that is there's very little research because I have a little bit of a business background as well. And the
Mhm.
one thing I was taught about when you deal with efficiencies, the ISO's registration programs, is that you need to look at effectiveness of those efficiencies, meaning whenever you implement a cut, you got to make sure that it's not affecting the operations and that. And it's one thing I've noticed in Ontario is there's no monitoring of it being effective or even to saying, does this really, is this a disaster? The only study that I came across was the one, I believe it was Steve Mantis, colleague of mine, advocate, and he had mentioned in 2007 there was a study of homeless people in Toronto, and they
Mhm.
found something like 58% were injured workers. To me, that's shocking. You know what I mean? To
Mhm.
say,
Yeah.
well, you're like the critics of injured workers saying they're all faking. Okay, great. But then is there any monitoring to say, are they really faking and going back to work, or are they literally, becoming homeless and all this stuff? Do you know of any research in that regard in the US?
Yeah, there is research. The research, the private research in that area tends to be from the insurance side. There's an organization in California that's of insurance companies that does a pretty decent job of researching certain issues, but they stay away from other issues. But formally, there's something in California called the Commission on Health, Safety, and Workers' Comp, which is an appointed body that includes labor and management, and they're supposed to be the oversight board for both workers' comp and for Cal OSHA. And do they do an effective job? I think they do as much research as is done, but I think they don't concentrate on all the issues. And there's never been, as far as I know, any sort of study like you just said, of what people who get injured, or people who are um, uh, sort of needing other benefits, other social insurance benefits, how many of them were actually injured on the job and should be going through workers' comp but aren't. So
Yeah.
that sort of
Mhm.
study, when in my earliest career, when I was at the Labor Department, when we were doing the study of compensation for occupational disease, we were finding that only 5% of the workers who had an occupational disease were getting workers' comp. It was much higher for injuries on the job, but for chronic injuries, it was a very low amount. And that was more history. It came out of a decision in the 1970s after the OSHA Act was passed to federalize the workers' compensation system for coal miners, because it was seen that they were really being taken advantage of by the system. And so because the states that most of the mining was being done in, West Virginia, Pennsylvania, Virginia, were doing really poor job on occupational disease. And so that there was a federal system of workers' comp set up called the Black Lung Benefits Act. Our study at the end of the 70s was to look at, were there other occupational diseases that maybe should be federalized? And we were looking at asbestos-related disease, cotton textile dust related disease, bisonosis, and radiation-induced disease to see if those should be federalized. And I think we were coming to the decision that there should be more federal because the states were not doing a good job on those. But that's when Reagan got elected and the office was disbanded. So
Well, on that uplifting note, we'll end the podcast, and thank you very much for getting up at the crack of dawn to be with us.
Yeah, 3 hours
it's a,
earlier than us, so I really
it's
do
an
appreciate
honor,
it.
and I should say that we are trying to do with some people in what's called committees on occupational safety and health in the states. We're trying to model a injured worker support network based on ONOWIG, on the Ontario network. So we're trying to learn from you as to how to put worker voice more back into the system.
Well,
And
thank
we're
you for
learning
that
from you as well.
compliment, and we'll end the podcast here. Thank you.
Thank
Okay,
you, Glenn.
thank you.